After many hours of public hearings and deliberations, a year and a half of litigation, an adverse 88-page decision by the Hartford court, and the expiration of the extension of time to appeal, Ridgefield's Inland Wetlands Board had little latitude, as the court ordered it to approve a plan to allow a 14-unit development on less than a half-acre of land in the Wetland Upland Review Area at 27 Abbott Avenue in Ridgefield, Connecticut. The cost of an appeal of the court's decision was prohibitive, and its outcome uncertain. Ridgefield's Inland Wetlands Board had little more they could do. Here is the public portion of their conference with their attorney, who had failed to defend their decision.
That brings up 27 Abbott Avenue. And Tom, could you run through us what the process is from this point?
Yeah, as we've discussed previously, the Superior Court issued a judgment requiring that a permit be issued, approval and permit be issued for this project. So at this juncture, it really boils down to adopting a resolution, which is pretty standard in something like this. I would suggest that the resolution identifies all the pertinent documents, meaning the latest set of plans, landscaping plans, drainage calculations, the usual list of the operative plans for the permit. The reason for the approval of the permit would simply be in accordance with the judgment of the Superior Court, so it doesn't need to be lengthy in that regard. And then the judge's decision did say to approve it consistent with conditions consistent with his opinion. So certainly, you have some standard conditions that you attach to these approvals, and I would suggest that those would be fine, soil and erosion, bonding where necessary, those kind of things.
Okay. So what you're saying is that we need to figure out in that list of documents which ones are the most recent versions. Is that? Yeah.
I mean, I don't know that the record was that lengthy in terms of those types of documents. That's pretty standard in these applications.
Yeah, we have quite a few documents and versions. So
right.
We'll just go backward in time and reference the current ones. Okay, I get that. On what I think is the final plan, and one was the invasive species control plan for the planted area. And if I'm reading that correctly, that gives only 1 year of monitoring of invasives. And normally we have, for plantings, when we request the bond, the plantings have to survive for 2 years. And so that doesn't seem to match up to me that you would have only 1 year on. Is that something we could specify should run concurrent with the planting?
Yeah, if that's your standard condition for that,
yep.
I don't think that's a problem, and I don't think the applicant would have a problem with that.
Okay. Fine. Okay. And same document included a list of construction sequence. We have, of course, the erosion and control, and then we have a construction sequence there. And again, the question is, what kind of construction monitoring are we going to have so that we can be assured was stated and that is in the plans happens in the correct order and also is done correctly, as we're talking about something that's underneath pavement in the end.
Right. Again, if that's something in a case like this that you would attach as a pretty standard condition and it's what you consider reasonable, then I would say that that would be okay as well, to include periodic monitoring to make sure that the sequencing is followed, as well as the steps are completed in the sequence.
Right. Okay. Anyone else comments?
Just a question, Tom. I wasn't involved with the original vote on this, so should I abstain? I think probably not vote on it since I wasn't there at the start, I think.
Yeah, that's probably more appropriate, Keith.
Okay, thank you.
Alan?
Tom, one of the questions I would have too is, can we, obviously, this is a unique construction plan, the constructing of a 5-foot high retaining wall around most of the property in order to lift it up in elevation so that their stormwater management plan could function as they presented. Can we introduce monitoring locations adjacent to their stormwater management to verify that the separation of the stormwater management practices to a groundwater table, which they claimed would be achieved, would actually be achieved in practice? Once it's constructed.
Well, don't you have
because that would be something that I think is reasonable. It's a common approach, is to provide some type of monitoring so that we know that it's functioning as intended. And I think it's something that we should have in place.
For how long,
Alan? That monitoring, the monitoring itself is there, period. It's a perforated PVC pipe, typically, with gravel around it. It's inserted into the ground adjacent to the stormwater management practice with a cap on the top of it. And once it's installed, it's there. So one could always, the town, if it wanted, 3 years hence, 5 years hence, 3 months after it's constructed, be able to confirm that the conditions are as presented. We wouldn't want to be in a position of having the applicant remove something like that, because that's disturbance that's unnecessary. But I think having a monitoring location adjacent to their stormwater management practice would be extremely beneficial to us in order to monitor that it is functioning as they presented.
Yeah, I don't know how to answer that particular one, Alan, because I don't know what's involved in adding that to the site construction or how expensive that is. I mean, certainly if you're requiring an engineer to certify that construction was completed pursuant to the plans, that goes a long way in requiring things to work as they said they would.
But all that says is they installed the number of chambers that they said they were going to. That's all it says. I should know because I do this all the time.
Right.
Very often, in a lot of instances, I myself have put in monitoring locations, so I know that it is functioning as in accordance with the design. That would be something that I would certainly want to have in there.
Well, I could certainly discuss it with the applicant.
Oh, I know what they're going to say, but but why would they want to have something that could prove that their conclusions were potentially, not necessarily 100% accurate?
Well,
in terms of this, I'll be kind.
I understand. The court, the court has said that those plans. The court has said those plans can be built. We can attach.
I understand, but that's the court.
And so, if it turns out that the applicant's fine with that, Alan, then we're okay.
Yeah. No, yeah, the court said it could be built, but putting on a monitoring location adjacent to their stormwater management doesn't impact the overall design. What it does is it gives us a window as to know that it's functioning as they said.
Okay, so
Yeah.
you will ask that question.
I will.
And I know the next step beyond that would be to say, if it isn't that way, because I still think they're creating a bathtub. That's the term I use during the the meetings and the public hearing. That we could link that to their ability to draw a building permit. That would be the next step beyond it. In which case, we know that the design is. I can take a look at it and say, oh yeah, they installed what they said they were going to do, but does it function like they said it would? We wouldn't know that until such time as we physically observe what's there, what the groundwater conditions are.
We have the right to inspect a valid permit at any time, I believe, in our regulations, don't we?
Well, this gives us a window to it, though. And it's not, putting in a vertical PVC pipe or a couple of vertical PVC pipes adjacent to a stormwater management practice is not exactly busting the budget. That's a very minor addition.
Right.
And you know that too.
Okay.
Yeah.
Anything else?
I don't think we have the flexibility of anything else.
Okay, well, that's fine. Want to make sure we're covering what we want to cover, and we'll see what comes back.
Well, we
And
had
then
a bit of a list, Tim.
Yeah.
There's a few things on the list.
Well, and I think the other thing to point out is that during this whole process, we were very involved in making sure we got the best product we could here. But I think Alan is correct. Hard to know until it's built and you see if it works. Since there was that was our main concern. So
That's one way of looking at it. I mean, the glass half full is that you took something from the beginning and towards the end, even though it was denied, it was still vastly improved from what it was at the beginning.
Exactly.
true. Okay. So
I don't know if I would use the word vastly, but we'll just say it was modified
it was modified.
in response
Yes.
to our comments. That's a term I'll use.
Right. Okay, so Tom, you'll let me know what you hear back,
Yep.
and then we'll start working on drafting the resolution so that hopefully we can send it out to you ahead of schedule, ahead of the meeting to have a look at it and go from there.
Great.
It for now. Thank you. We have next 25 Seymour Lane wetlands violation remediation plantings.